Morning, everyone. I hope you can all hear me. Please let me know if you can't. I should be able to see any comments that you put on the chat channel. So welcome to today's session, which is the first of our lunchtime briefings about Australian immigration for employers. Thank you for joining us, and my apologies for running a few minutes late this morning. Today, we'll be looking at an overview of employer-sponsored immigration for businesses and really trying to get a bit of a lay of the land as a starting point to think about what are the appropriate visas depending on different circumstances of your employees, your prospective employees, overseas contractors, or others who may be coming in to deliver services in the business. So without further ado, I'll share my screen and we can get started. So hopefully you can all see the screen there. Please give me a shout out if that's something that you can't see at the moment. Okay, so today's session will be a rundown on the visa options for employer sponsors. Please feel free to type your comments into the chat box, or enter any other details that you or any questions you may have, comments, anything else like that. I'd love to hear from you. That would be really fantastic. So as a bit of an overview, first of all, we'll be looking at the visa environment. So what sort of visas are out there? What are the different statuses people can hold in Australia when they come into Australia to work for you, or just floating around doing different things? We'll look at business visitors. Okay, so these are people who are not sponsored, but who may come into your business if you're a multinational, or who may be visiting from an overseas organization which has a relationship with yours. We'll move on to the more standard work visa programs, the subclass 482 visa under heading 2, sponsorship. We'll look at the nomination requirements in the 482 visa program. So the 482 visa, as we'll discuss, is made up of 3 parts. We've got sponsorship, nomination, and visa. We'll move on to other programs that exist in the Australian immigration system, things such as activity visas, which come into play in a variety of different situations. You may have someone come over from overseas to do training, for example. They're not going to be working with you. They may be a visiting researcher. They may be a visiting medical practitioner, but they come into your organization and they're doing something other than work. We'll look at the COVID restrictions, which have almost completely disappeared at this point in time. We'll talk about permanent residency options for employers to support employees to go through to become permanent residents, which is a really key part of the attraction and retention piece. And then we'll have a talk about who is a family member in the context of the 482 visa program, some of those other activity visas and so forth, as well as permanent residency. And then we'll talk about people leaving and the sponsorship obligations. And I can certainly circulate the slides through to everyone. There's a lot of detail in the slides. I won't be reading everything. I will just be speaking to the slides because we have a limited amount of time today. But if you have any questions after the session, you'll get a copy of the slides and you can certainly reach out to me for any further clarification. So an overview of Australian visas. Australia is one of the few countries in the world to run a universal visa program. That means that anyone who is not a citizen who enters Australia, including the Queen, needs to get the right visa before they come. Now, there are some limitations to that, in the sense that if a person arrives in Australia without a visa seeking protection as a refugee, for example, then they can do so. Okay. Obviously, this is an area that's caused a whole lot of issues, tensions, frictions over the last few years, but essentially anyone coming into Australia needs to obtain a visa. And the way the Australian immigration system works is that that visa should be consistent with your intentions in Australia. So it's not appropriate, for example, to get a visitor visa, which is essentially for tourists and people visiting family to come and do work, okay? Nor is it appropriate for someone on a, let's say, a student visa to come out and intend to stay permanently with their partner, okay? So the visa is supposed to align with your intention. And we have two statuses essentially in that universal visa environment. You are either lawful, meaning you hold a valid visa which permits you to be in Australia, or you are unlawful. Unlawful people can include people who've arrived without a visa. They include people who've overstayed their visa. And there are different ways to regularize your status, which is to say to go from someone who has potentially overstayed a visa, they forgot, they didn't leave the country before their visitor visa expired or their student visa expired or whatever visa, they can seek a bridging visa. And then in some circumstances, they can potentially seek another visa while they're in Australia, although quite often they will have to leave. Now, in terms of residency status, we have a few different statuses. You can be a temporary resident. A temporary resident holds a temporary visa and they are permitted to stay until the end of that visa. And typically the end date of a temporary visa is tied to either a fixed date, such as you receive a visitor visa, it's valid for 3 months from the date of entry. You arrive on the 1st of January, you must leave by the 1st of April. Or it's fixed to an event. So some temporary visas, such as the 494, which we'll speak about later, is a long-term work visa, and it will stay in place until 5 years, or you obtain the permanent 191 visa, which is related. So visas aren't necessarily only about fixed dates. Sometimes they are connected to an event. We also have bridging visas. Now, bridging visas in the Australian system are designed to bridge a gap between, say, when you've applied for a visa, you're in Australia, you hold a visitor visa, you apply for a 482 work visa. Even if the visitor visa expires, you will continue to hold a bridging visa through that period until a decision is made on your 482 visa. Now, in many cases, bridging visas are automatic in these sort of circumstances, and that's designed to make things as smooth as possible. But on other occasions, you may need to actively apply for a bridging visa. For example, someone who holds a bridging visa A, which is the standard bridging visa that allows you to remain until a new application is decided, isn't able to leave the country and return. In that situation, they need to apply for what's called a bridging visa B. A bridging visa B allows a person to depart and return to Australia, but you have to consciously apply for a bridging visa B in that situation. We also have permanent residency. This is the right to remain in Australia indefinitely and is often the stage that follows temporary residency if people are seeking to stay long-term in Australia. I won't go much further into that, although there are additional things that we could talk about because it doesn't in fact allow you to travel indefinitely. It allows you to stay in Australia, but not necessarily to travel. And then we have citizenship, which is full membership of the Australian community with the right to vote, access to most or all social security, although there are limitations on that in some circumstances for new migrants, as well as being able to seek an office in the Australian, government, state government, parliament, so forth. So those are the different statuses we have in Australia. Very briefly, since the Hawke era, we have divided our permanent visa program into 3 categories. Skilled, which is the one that most employers will have dealings with during their day-to-day work, although that's not to say you won't come across people who hold partner visas or other non-skilled visas. But if an employer is seeking to support someone to obtain a visa, a permanent visa, then it will be through that skilled pathway. The family pathway currently makes up about 30% of the visa mix. Each year, the government allocates a certain number of places to skilled family refugee, and at present, it's about 30%. So that has decreased significantly over the last 40 years or so, since the 80s, to become a minority component of the program. And then we have refugee, which makes up a very small percentage of the overall program, probably less than 5%. Okay, so that is maybe 5 to 10%. That is the permanent visa environment. Okay, skilled family refugee. When we look at temporary visas, things aren't as organized or coordinated. We have a whole variety of different temporary visas. Some of them are sort of a collection of visas. So when I say visitor visas, there are a variety of visitor visas, probably 4 or 5 at least, depending on the country you're coming from, depending on whether you're seeking to stay longer term, because, for example, you might be the parent of an Australian citizen, or you need to be supported by your family to make that application because you're deemed high risk. Okay, and the same goes with a lot of the other visas. It's not just one in many of these cases. There are multiple visas, or they may be visa streams. So, for example, the activity visa, there's only one activity visa, but underneath it, when you look at the next layer down, there are what we call 8 different streams, depending on whether you're an entertainer, a visiting sports person, a visiting actor, and so forth. So there's a large number of visas in Australia, and it's really important to pick the right one based on your purpose. Okay, so we've got just a variety up there that I've selected. So student visas, training visas, graduate visas. We do have temporary family visas. So there are temporary partner visas, temporary parent visas. Special category is the visa that New Zealand citizens hold. And that is actually, in the words of Peter Mayers, who's an academic researcher in this space, indefinitely temporary. So New Zealand citizens who come into Australia, they get that visa, but it is a temporary visa and they need to take additional steps if they ever want to become permanent. We've got our working holiday visa, commonly known as the backpacker visa. We do have temporary protection and refugee visas. And then we've got PALM, which is the Pacific Australia Labour Mobility Scheme, which is a relatively new program aimed at bringing in agricultural workers and other workers to assist Australia, but also benefit our Pacific neighbours through remittances and so forth. So for employers, what are the key things that we need to be looking at and thinking about? Well, it depends, again, on the purpose of the person coming to Australia. So if we classify things broadly into short, medium, and permanent outcomes, for short-term visas, and by this I mean either visas that are, for sort of a maximum of 3 to 6 months, or that are unconnected to your sponsorship as an employer, we've got business visitor visas. Okay, so this is a situation where someone comes into your business from overseas. They're not actually going to be working. They're there for meetings, they're there for training, they're there for a variety of different purposes for a very limited time, and they're not actually going to be doing work. We have short stay work visas. So these are visas typically for 3 or 6 months maximum, where someone is going to come into your business, either from an overseas office or because they're an overseas contractor, for example, delivering services. And that's commonly used for things like engineers who are commissioning work, technicians who are coming out to Australia to fix machinery, for example, and other non-ongoing projects. We have the working holiday visa, which is not a sponsored visa, but normally allows people to do 6 months work. Okay, and it's been very common over the last few years, although COVID being the exception, for working holiday visa makers to come out from Europe, from Asia, from wherever they may be coming, come to Australia for a 12-month period and find different work opportunities, whether it's in healthcare, whether it's in IT, whatever it may be, and then seek a further sponsored visa from the employer. That's very common. And in fact, at the moment, the government is allowing working holiday visa makers to work for 12 months with no restriction, 12 months for the same employer. And in the past, that used to be a long time ago, that used to be 3 months, then it increased to 6 months, and now at the moment it's 12 months. Okay, so it's becoming increasingly used as a work visa, although that is not strictly the purpose. And then we've got the students, who obviously make up a large cohort of I don't want to say low skilled, but often, jobs that are temporary in nature or casual in nature, whether it's in hospitality or other sectors, and losing a large chunk of that student cohort during the pandemic has been very problematic for many employers. In the medium term, we've got the 482 visa. That is the temporary skill shortage visa. It is the most stock standard work visa in Australia, and it's the one that most employers will use to sponsor employees in their business. There's also a regional 494, so that's skilled employer sponsored regional. It has a wider range of occupations than the 482 visa, but it's only available in regional areas. And the threshold to apply for that visa is actually quite high. It's higher than the 482, which is a bit of a strange way of setting things up. Typically, regional visas in the past have been concessional, which is to say the threshold has been lower. But in fact, the 494 visa, because it is really a pathway to permanent residency, okay, it's closely tied to this 191 visa, the threshold is very high. We also have activity visas, which I'll discuss more in detail later, and training visas. Now, permanent visa options for employers are quite limited. Really, there is the Employer Nomination Scheme 186, which is the permanent arm of the 482 visa, or there's the 191, which will be, in the near future, the permanent arm of the 494. Now, that hasn't been completely set up because at this stage, the 494 was introduced and required people to do 3 years full time before you could move on to the 191. So the government, being who they are, set up the 494 first and then said, we'll work out the 191 later. Probably wasn't the best idea, but that is the way it is. And so we're still waiting for clarification around the exact process for the 191. So that's the environment for employers. And now we'll drill down into a little bit more detail about each of them. So short stay visas, we essentially have three main options. And they are largely similar. These three visas, the ETA, the e-visitor, and the 600, are largely similar. The main difference is going to be the nationality of the applicant. So the ETA is available to low-risk nationals, and the government essentially does a lot of data analysis over the course of many years to assess who is low risk and who is high risk. And this is based on, essentially, from what we understand, overstay rates. So the government will have a lot of data, a lot of matrices, which set out, a person is, a 35-year-old Swiss national, male. The risk of overstay is 0.0001%, because over the last 10 years, we've had 100,000 people from Switzerland and only 3 have overstayed, for example. And then on the other hand, they might have a visa. They might have on the same matrix, it might say, Ugandan national, 50-year-old female, and then it'll say, the risk is 0.3%, for example, and it'll be based on the fact that over the last 10 years, they've had 10,000 people and, 250 people have overstayed, okay? And that's how they sort out risk. And essentially what they've got at this point is the ETA is for low-risk nationals, including US, Canada, Singapore, Japan, Malaysia, South Korea as well. And it is an online electronic visa that's granted normally in the space of about 48 hours, but it can be a bit longer. And all 3 of these visas have at least 2 streams: your standard visitor stream, which is for tourists, and your business visitor stream. And the business visitor stream is for people who are coming out to do business activities, okay, as distinct from work. And we'll look at that in a moment. The e-visitor is essentially the same as the ETA, but it is for EU nationals and the UK now, and it is free. And that distinction between the ETA and the e-visitor, as I understand it, exists simply because we have different bilateral agreements with those countries. They give us a different deal. So, for example, it's free for Australians to go to Europe, and therefore our e-visitor is free for European nationals, where the ETA, for example, it costs us money to apply for a US ESTA, and we basically apply the same principle in return. The 600 visitor visa is for high-risk nationals. And high risk is essentially anyone who isn't in the other 2 categories on the left-hand column. So anyone who is an ETA or e-visitor eligible is going to be deemed high risk. And that means the application is a bit more detailed, there's a bit more information, and it's likely that the processing time is going to be more like 1 week to maybe even a month if you're unlucky. Okay, and the department is quite inflexible on these issues. We've recently had a situation where we were assisting a batch of, I think, 10 people thereabouts to come out on this 600 visitor visa. 6 or 7 of them were granted within 48 hours, and the other 3 are still pending 2.5 weeks later. Okay, so this is the type of scenario where it's really important to plan ahead. We've tried to escalate these applications to the department. We've contacted at least 3 different contacted at least 3 different touch points, but we're still getting no joy. Okay, so this is the sort of scenario where it's really important to have that visibility ahead of time, to plan and to get things prepared well before any deadlines. Now, it appears there is a dot point, but the subclass 400 short stay work visa, it's the last dot point there. We've spoken about this already. It is actually a work visa. Okay, so the difference is the other 3 are business activities only. The 400 is for highly specialized, non-ongoing work, most typically. Okay. Now, in terms of business visitors, what is it that they can do? Well, we have to distinguish between work and business activities. Work is defined in immigration law as any activity that would normally draw remuneration. Okay, very, very broad. Business activities are carved out essentially from work, and they include things like making general business or employment inquiries, investigating, negotiating, entering into or reviewing a business contract. And then there's another couple of examples there. Okay, and a list of things that are definitely not business activities. Okay, such as supplying services or selling goods direct to the public. Now, distinguishing between these 2 can be challenging at times, because if you are, for example, a very high level person, a managing director, and you're traveling around the world, you know, you've come from head office in the US and you come to Australia, and your purpose here is to attend talks and discussions internally with the organization, it is pretty clear that your activities as a CEO typically involve things like those high-level business discussions. So it is both an activity that would normally draw remuneration, but it's also potentially a general business inquiry. Okay, so there can be a tension there, and it is important to look closely at what the intention is in Australia. It's also important to recognize that when someone's coming up for a one-off, it's probably not as important as someone who is coming 5, 6, 7 times. Okay, that is going to flag a lot more attention from the department. Okay, another important thing to be aware of, if someone has a 482 work visa and they're waiting to come to Australia, they've got a 482 work visa lodged, for example, and they're waiting to come for Australia, it's not appropriate to then come in on a business visitor visa or a subclass 400. The government is concerned that you'll be too tempted to work. Okay, so that's something that really needs to be treated quite carefully. Moving to the 482 work visa program. This is the workhorse of the Australian visa program. It is the main work visa for Australia. It has 3 parts. There is a sponsorship, which relates to the business or the organisation that is employing. The nomination, which relates to the role to be filled and must be highly skilled and meet other requirements. And then the visa, which relates to the individual who will be filling the role. Now, one of the interesting things about this visa program is it's all based on the idea that Australia just needs to fill those local skill shortages. Okay, it's just a stopgap to fill the need between now and when there's going to be a trained Australian. Okay, so unfortunately, at its basis, at its most fundamental point, it doesn't recognise a number of issues that have been occurring in the Australian labour market over recent years, such as, for example, the fact that there just aren't enough doctors, or there just aren't enough people who want to work as bakers, for example. So there are some problems inherent in this visa program, and it's something that no one has really been willing to grapple with over time. And as a result, we see a number of issues arise in the program because of the conflict between what it's really supposed to be about, these short-term skills gaps, versus what the reality is in the labour market. For example, there's no specific contemplation of an inherent right for companies to do an intra-company transfer. You know, you can't just say, oh, you know, I have my business in France, where we're a software development house. I want to send someone to Australia to get more experience. Okay. In theory, that doesn't apply. It's only when there is a shortage in the Australian business and a shortage in that local labour market, because you can't find an Australian, that you can transfer the person. And so these challenges are really just sort of papered over and ignored, but they do create real problems. So the first stage is a sponsorship. Now, sponsorship enables the organization to bring people in from overseas. It's a form of, if you like, it's like a statutory contract between your organization and the Department of Home Affairs. It's an acceptance from the Department of Home Affairs that you meet the standards, you're low risk, you're a good corporate citizen. And for the business, it's an expression to the government that you want to or need to access people from overseas. And there are several different varieties of these. So first dot point, overseas business sponsorship. This is for organizations that don't exist in Australia who want to bring people in to work, okay? And it might be because, you know, you run your company over in Serbia, you've got an agreement with Coles out here to retile all of their floors. You're going to send 10 contractors out for 6 months, and they're going to work their way around a bunch of different stores, okay? Standard business sponsorship is for Australian businesses who want to bring people in because they can't access those key resources in the labour market. An accredited business sponsorship is for, it's like a gold standard sponsorship. Okay, it's for Australian businesses. It provides streamlined processing. So there are provisions there for automatic approvals of certain applications based on salary, occupation, and other different factors. And so that's intended for businesses who are high volume users, who have a good history with immigration, and basically have a lower level of scrutiny on their applications. Now, a labour agreement is like a sponsorship, but it is essentially a one-to-one discussion with the government about either a specific industry or your company or organisation specifically, and its unique needs. So within the labour agreements, we have industry agreements, such as there's a pork industry agreement, a dairy industry agreement, a fishing industry agreement, there's a fine dining restaurant agreement. And what labour agreements do that's different from all these other visas is they allow for certain concessions. And those concessions might be, for example, in the pork industry labour agreement, you can get a senior piggery hand. Okay, and that's someone who works in a fairly hands-on way on the pig farm, not available through the standard program. Okay, you can't do that as a standard business sponsor. So it allows access to occupations that aren't on the list, and it can even give you concessions on English score or salary, and maybe a few other factors. The company version of that is very similar, but it's a much more detailed negotiation. The industry agreements have been negotiated between industry head peak bodies and the department. For a company agreement, you can get some concessions, you can get some wiggle room outside the standard program, but probably less than what the government would give to an industry body. Now, the last one on this list is the Dharma. Now, Dharmas are essentially where a labour agreement is held by a council or a group of councils or a state government body. And for example, there are two Dharmas in South Australia. There's one that relates to Adelaide, and then there's one that relates to regional South Australia. And those agreements have been negotiated between the state government and the Department of Home Affairs. The state government plays a role in determining who is allowed to use the program, and they provide more concessions than the labour agreement programs. So there's a wider variety of occupations. So for example, the Northern Territory Dharma allows you to access truck drivers, something that would be certainly not accessible under a standard labour agreement or under the standard sponsorship program. So DARMAs are designed to give greater access. The challenge with them is that there are multiple layers of bureaucracy and the requirements become very onerous. And as a result, despite the proliferation of DARMAs and despite the Department of Home Affairs pushing more and more DARMAs and encouraging people to apply, the actual number of applications through those programs is very, very low. So a couple of years ago at a regional conference, the Northern Territory state government was speaking about their DARMA. They were being sort of put forward as the peak example, the best example of how DARMAs can benefit the country. In that year, I think the number of 482 visas was about 40,000, and the number of visas that came through the DARMA was under 100. I think it was actually closer to 50. So whilst DARMAs might feel a really niche requirement, they're actually very hard to use because of the level of bureaucracy that's involved. Moving on to the nomination. The nomination is a skilled position. Now, when the 482 program changed from the 457, one of the really big changes that happened was that the government said, instead of saying any occupation which requires a certificate 3 and 2 years work experience or above, okay, so you've got the certificate 3, certificate 4, diploma, bachelor's degree, and so forth, any occupation that requires a cert 3 and 2 years experience is eligible for a 457 visa. The government said, no, what we're going to do is we're going to split it into high value and low value. And the high value occupations will go on what's called the medium and long-term list, and the low value occupations will go on what's called the short-term list. High value occupations will get access to a 4-year visa and pathway to permanent residency. And the low value occupations will only get two-year visas with no pathway to permanent residency. And this has created huge issues in the visa program because for a whole variety of different reasons. One reason is that the lists change and they were intended to change, which creates a lot of uncertainty. So if you're in Australia and you're on that medium and long-term list with a pathway to permanent residency, but while you're here, your occupation is removed, okay, and this happened, for example, to anaesthetists a couple of years ago, your pathway to permanent residency disappears. If the occupations can also just be removed from the list, not all occupations are even on a list, occupations can be removed entirely. Occupations that are in that short-term pathway really struggle to attract and retain mid-level and senior applicants, because those people are quite often they're older. They often have children who are teenagers or approaching their university years. And the idea of disrupting their children's life to come to Australia when there's no guarantee that they'll get to stay or become permanent residents is unappealing. They'd often rather go to Canada or the UK or New Zealand or another destination where they can get that permanent visa. So the nomination is a really important part. You need to determine what's the appropriate occupation classification. Is it on the short-term list, the medium list, or the regional list? Okay, and the regional list is now really being moved across to that sort of 494 visa we mentioned before. And what does that mean for the applicant? Okay, so that's often a really important starting point for this discussion. In terms of the requirements for the nomination, the occupation is one of the most critical, if not the most critical. The market salary rate. So everyone under this program must receive what an Australian would receive in the same position. And you look at that by looking at what people in the business are already receiving, what the award or the EBA says, or if there's no one in the business doing the job, what do job advertisements, salary surveys, so forth. Labour market testing requires that employers advertise to make sure that there are no Australians who are suitable for the role. Technically speaking, there's no legal obligation on you to hire Australians if you do the labour market testing and someone applies, but really it's intended to push organisations to say, well, if there are quality candidates there in the market, you should be engaging that person instead of engaging someone on a 482 visa. And for most employers, that will be more cost effective in any case. But the reality is, often these people are already in the employer's business. They know they want to sponsor them, but they still have to go through this labour market testing process. Moving on to the visa, it relates to the individual. The individual must have the skills qualifications for the role. They must have relevant experience, which is at least 2 years typically. And they must also have English ability to the standard required, okay? And people from a certain number of countries, magic passport countries, we call them, US, Canada, UK, Ireland, New Zealand, they do not have to do any English test. Most other people will have to do an English test or demonstrate that they've studied in English. And then, of course, people have to meet the health and character requirements, good health, good character. Now, I know we haven't got much time, so I'll move on quickly. There are a variety of other visas that businesses may need to look at or may look at during the course of events. So the 403 International Relations Visa, probably not relevant for most people here, although this is actually the visa that the Seasonal Work Program or the new PALM, Pacific Australia Labour Migration Scheme, operates under. 407 Training Visa. So if you have someone in your business who you're delivering training to as a trainee, either because you're upskilling them or they need to meet certain requirements for registration, the 407 training visa can be suitable. And this includes for medical graduates, for example. That's one option. It can also be for a variety of different people who have finished their qualification, but aren't quite at that standard that's required for the 482 visa. Because if you recall, you need 2 years full-time work experience. The 408 activity visa is very similar to the 482, but there's a variety of different streams. So people who are involved in academic research, people who are on an exchange program, people who are working as an entertainer in Australia or doing sport, okay, professional sports. These are all different streams within that 408. Now, permanent residency is often the motivation of people who come to Australia on a long-term temporary visa. I like to say that Australia is a lifestyle destination, probably most comparable to New Zealand or Canada, and perhaps in contrast to somewhere like the US or the UK, where people who are seeking perhaps a longer-term career progression are more likely to go. Access to the 186 visa is through employer sponsorship. And it is occupation-based, which is to say you have to be in one of those good occupations in order to be able to come through to permanent residency at this time. Now, Labor have indicated that if they are elected, that they may get rid of that, and anyone who has a 482 visa would be able to get permanent residency on the basis that the current program is essentially a guest worker program and not consistent with what they see as Australia's values. There are 2 streams to gain access to this visa: temporary resident transition, where people have been on the 482 for 3 years, or direct entry, where people have a positive skills assessment in their occupation and at least 3 years experience. Typically, you have to be under 45 to apply for this visa. There are some exceptions for New Zealand citizens, for senior academics, for regional medical practitioners, and high income earners, but the access is very limited over the age of 45. And it's important to note that outside the employer-sponsored system, it is very, very hard to get permanent residency at this point in time. The government decreased the permanent allocation for general skilled migration, which is non-employer sponsored, from about 30,000 in around 2018, 2019 to 10,000 this year. So it's very, very, very high pressure, a lot of competition to get this visa. So family members, it's important to note, you know, a lot of cultures, a lot of countries, it's considered quite common that, you know, grandma and grandpa are part of the family. That's not the case in Australia, according to the legislation. Only spouses and children are eligible to be included on these visas. Okay, so for spousal, it can be a legal marriage or a de facto marriage. De factos typically need to be in at least 6 months for a temporary visa or 12 months for a permanent visa. And you need to have evidence of that. Same-sex marriages are, of course, recognised in Australia, and spouses have full work rights and study rights. And that's distinct from some other jurisdictions. I know until at least very recently, the US didn't allow spouses of work visa holders to work themselves. Children, biological, adopted, or stepchildren, custody issues, however, can cause huge issues and huge delays if there's a parent who doesn't want the children to come to Australia. That's something to be aware of. And typically you have to be under 23. Okay, if you're over 23, you have to be incapacitated, which then raises a whole bunch of issues around your health. Okay, so Australia is, immigration is one of the few areas where it is still entirely legal for the government to discriminate on the basis of illness, disability, or other, other factors like that. In terms of COVID restrictions, things are pretty much back to normal. I was looking just yesterday at the Victorian State Government's website. They were saying, you have to take a test after you arrive from overseas. You no longer have to be fully vaccinated to arrive from overseas. It's open slather again, essentially. With the visa processing at this point in time, we are still seeing backlogs from the COVID period. There are a whole bunch of applications that were lodged during the COVID pandemic that haven't been decided. Most 482s are being processed relatively quickly, although some are taking longer. So 4 to 12 weeks is what we're seeing. But there are a whole bunch of applications that are stuck in the system that are 12 months old, 18 months old. And, we're following up on those with the department, but seeing very limited traction or movement. Now, if you are a business sponsor, it's really important to understand that's not the end of it. Getting the agreement, great, done. You can't just put it in a drawer and forget about it. It is something that needs to be managed. It's a compliance issue, and it can be challenging at times because it touches on a whole different range of points across your business. So you need to be doing a number of things as a sponsor, and the more people you sponsor, the more difficult it becomes. So you need to notify the department of changes about the business. Okay, so if there's a change of business details, such as a change of business name, a change of entity structure, a change of directors, or if the entity itself ceases, pardon me, you have to ensure that your visa holders receive equivalent terms and conditions to what an Australian would receive. So it's not a matter of saying, okay, so the market salary rate for this baker is X. You have to be making sure that, every time you do a salary review for your Australians, all of your temporary visa holders are part of the same process and part of the same system, okay? And the whole idea is you can't be lowering wages, you can't be undercutting what you would give an Australian based on the fact that someone's on a temporary visa. Temporary visa holders can only work in their nominated occupation, and that's really important. Now, what that means is if you've been hired as a supermarket manager, you can't go and work on the cash register, okay? So it's really important for organizations to understand that, to monitor that, to track that, and to train staff that is the case. Because, it's one thing to have your policy internally, but it's a whole nother thing for then a line manager to direct a staff member to do something that's outside the scope of what they're allowed to do. Unless you have actually delivered that training to the line manager, the organization is liable. The directors of the organization are liable. The penalties in this area are very significant. And it's really important that organizations be across compliance, training, and so forth. You have to maintain records for all your sponsored workers. These include things like position descriptions, remuneration, whether you've paid return travel costs, when they ceased employment, all that sort of stuff. You can't transfer costs. Now, I've just written it, not pass on travel costs, but that's an error. Please ignore that. What you cannot transfer is you can't transfer the cost of becoming a sponsor or nomination. Okay. There's also a prohibition on passing on recruitment costs, but what constitutes a recruitment cost is a bit of a grey area and open for some discussion. But if you have concerns, reach out to me. It's well worth talking about. You also have to cooperate with inspectors from the Department of Immigration. And it's worth noting that Fair Work inspectors also exercise immigration powers. And then one of the most critical, you have to notify the department when the employee ceases. And typically for most of these obligations, you have 28 days to make that notification, okay? So those are some of the sponsorship obligations. Just a few issues to think about. For business visitors, if people are coming in and out frequently, that may start to raise questions. Okay, if you have a business visitor on an ETA who's coming into the country, twice a month over a period of three or 4 months, they're going to be stopped eventually, and they're going to be questioned about what they're doing. Because whilst there is flexibility that allows for these general business activities don't tend to happen all the time, every week, etc. They are things that are, semi-frequent, and consistent arrival in Australia is likely to raise questions. Now, we didn't talk about it in much detail, but the subclass 400 actually has 2 streams. Highly skilled, highly specialized, where you can't source workers with that skill set in Australia, okay, because of the company's got intellectual property that no one else does, et cetera, et cetera. There is also a national interest stream. That national interest stream is only available in very rare circumstances. The difference between highly specialized and national interest is national interest doesn't have the prohibition on ongoing work. So highly specialized work is only for people who are doing a maximum of 3 or 6 months. Where work goes beyond that, only the national interest stream is going to be appropriate, or a 482 visa, okay? And you're not supposed to come in on a 482 visa and intend to apply for a 482. If the worker comes in on a 400 and after 2 months it becomes obvious that the scope is actually completely out of whack and it's going to take a lot longer, then you can apply for a 482, but it shouldn't be the intention at the time. And just in terms of 482 visas, if you've got people coming from overseas, issues like if there is a police clearance issue, as in someone has a criminal record or they have difficulties getting a police clearance from their country, and there's a number of those that are very difficult. Hong Kong, Japan, Singapore, Saudi Arabia, many African countries are very difficult or impossible to get a police clearance. That can cause a significant delay, so be aware of it. Character and health issues, again, can cause huge delays, okay, like months or even years. So be conscious of that, okay? If you're looking to recruit someone on an urgent basis, it's probably not a question that you ask most of the time as an employer. Shouldn't be. But when it comes to immigration, it's something that may well mean that your preferred candidate just can't get into the country, okay? So that's the end of the presentation. I hope that's been a useful overview of Australian immigration. I think we've covered off many of the areas that for employers are going to be most critical, but I'd be very happy to field any questions. I've got until 1 o'clock. So if anyone has any questions about Australian immigration at this point, please feel free to type them into the chat box, or I can let you speak if you would like to do so. Does anyone have any questions? No? All right. Well, thank you, everyone. Next week, we will be running some additional sessions. We'll be running a session on the employer compliance, okay? I think that will be in 2 weeks. And then we'll also be running, no, that'll be next week. And then we'll be running a session on the 2nd of June about current issues in immigration for employers. So thank you for your time. And if you have any further questions, let me know. And Bruce will shoot those slides around for everyone. Feel free to pass them out to the team. And if you'd like further training or further information, please feel free to get in touch. So over and out from me, and have a wonderful day. Thanks, everyone.